Welcome to the Deep Dive, the show where we cut through the chatter to bring you what truly matters. Today, we're diving into something incredibly complex and frankly often surprising. We're looking at the shadowy world of civil lawsuits, specifically zooming in on some pretty serious allegations of fraud within personal injury claims.
Yeah, and for this deep dive, we've gathered some really compelling source material. We're looking at a real-world legal document, a bill of particulars from a specific Queens County case. And we're also drawing from an in-depth analysis of ongoing legal battles against alleged fraud rings, which includes fascinating details from a federal lawsuit, actually.
Okay, so our mission here is clear. We want to extract the most important insights from these documents, help you understand the alleged mechanics of these schemes, how they're being addressed in the legal system, and, what they reveal about the broader legal landscape and, crucially, its impact on you, the consumer. Get ready for some truly eye-opening details. Might make you rethink how some of these cases actually unfold. Okay, let's unpack this with a specific real-world example because that's where the rubber meets the road, right?
Exactly.
We'll start with that formal document you mentioned, a verified bill of particulars from a case in Queens, New York. It involves a plaintiff named Jose A. Diaz-Janao against Samaritan Holding Corp. and Samaritan Daytop Foundation, Inc.
Right. So a bill of particulars, for anyone not familiar, it's essentially a formal, detailed statement of the claims in a lawsuit. It spells out exactly what supposedly happened and what injuries are being claimed.
Okay.
In this document, filed June 26, 2025, Mr. Janao alleges an incident occurred on June 13, 2024, midnight, on a sidewalk at 8883 Van Wyck Expressway in Queens.
And the claim is negligence.
Yes, the core claim is negligence by the defendants, leading to his injuries because of a dangerously maintained sidewalk. He describes it quite vividly, actually, as unsafe, broken, cracked, uneven, wholly chipped, depressed, raised, unsmooth, loose. Basically saying it acted as a nuisance and a trap.
Wow, that's quite a description. And then the injuries. This is where it gets really interesting, right? Extremely interesting.
This bill of particulars outlines an astonishingly extensive list of Mr. Jano's alleged injuries, all supposedly from one single sidewalk fall.
That's the claim.
We're talking everything from multiple severe left knee issues needing complex surgery.
Arthroscopic surgery, extensive synovectomy, that's removing the joint lining removal of loose bodies.
Right.
Partial medial meniscectomy, copulation arthroplasty, all scheduled for December 11, 2024 at Surgicore Surgical Center in Jersey City.
And that's just the left knee.
Exactly. Then there are right knee injuries, partial ACL tear, chondromalacia meniscal tears,
Okay.
significant cervical spine issues too, disc herniations, disc bulge, disc displacement, sprain, strain, radiculopathy.
So neck problems and lower back.
Lumbar spine problems, yes. Annular tear, that's a tear in the outer ring of a spinal disc. Herniation, numbness, tingling, and head and face injuries on top of that. A limp cut, bruising, skin wound.
It just keeps going. Headaches, vertigo, difficulty sleeping. And many injuries are described as progressive, believed permanent, with new arthritis, some needing future surgery.
The sheer breadth and severity, it immediately makes you wonder, doesn't it, about the legitimacy of the damages being sought here.
It certainly raises questions, and what's particularly fascinating connecting this specific case to our broader investigation is a unique procedural detail.
What's that?
In this Jose A. Diaz-Janao case, the index number is 708-972-2025. The plaintiff himself, Jose A. Diaz-Janao, actually verified and signed the bill of particulars directly.
Not his lawyer. That's unusual.
Very unusual. Typically, an attorney from the law firm would do that. This is explicitly noted in our source material as a new pivot by the law firm involved, which is Subpoenas Associates, LLP.
A new pivot.
And this seemingly small procedural change, as our source highlights, is actually seen as a critical red flag. It sort of foreshadows the broader fraud allegations that are now emerging against them.
So a seemingly unusual procedural move for a law firm. What exactly does our source suggest is the implication of that new pivot by Subpoenas Associates? And how does it connect to these broader allegations? Because the single case doesn't exist in a vacuum, right?
Not at all. That pivot starts to make a lot more sense when we connect it to the bigger picture, as revealed in our other source, which describes an ongoing fraudemic within the legal system.
Fraudemic. Strong word.
It is. This analysis delves into widespread allegations of staged accidents and fraudulent claims across New York, often involving quite sophisticated networks.
And when you say networks, what does that really look like on the ground? How do these alleged fraud rings typically operate?
Well, connecting it to the bigger picture, we see criminal charges have been brought against individuals, often called runners.
Runners.
Yeah, they essentially recruit people, allegedly, to participate in these staged accidents and fraudulent claims, often for a fee. Our sources specifically mention some high-profile incidents, like the viral Belt Parkway fraud ring MVA,
I think I remember hearing about that one.
and also a case against Liberty Coca-Cola Beverages, where a judge ordered fulsome discovery, basically, a very thorough investigation into a large fraud ring reportedly targeting commercial trucking companies.
And there are patterns.
Definitely patterns.
Yeah.
Using these runners, making false injury claims, inflating claims with unnecessary or maybe even faked surgeries, and involving third-party litigation funding companies, which is a whole other layer.
Right. And this isn't just one or two cases, you're saying.
No, that's the really disturbing part. The investigation identified over 20 similar MVA litigations and fraud actions across Kings, Queens, and Nassau counties.
Wow.
It highlights what our source calls a tired, recurring cast of plaintiff personal injury firms, and even lists specific medical providers frequently involved, including Surgicare, Citamed, Kolb Radiology, and Lennox.
The same names keep popping up.
Exactly, which naturally leads to the question, how do the accused parties respond, especially the plaintiff counsels involved in these cases?
Good question. When these allegations and discovery requests surface, are they cooperative or...
Well, according to the analysis, plaintiff counsels have aggressively fought these discovery orders, accusing defendants of going on a fishing expedition, and warning of opening a Pandora's box that would cause pandemonium in the legal system.
Strong pushback.
Very strong.
Yeah.
However, their motions for re-argument and appeals for stays were consistently denied, April, June, July of 2025, which really suggests the courts are taking these allegations very seriously and pushing back against that resistance.
So the chickens have now come home to roost, as one source dramatically puts it.
Seems that way. Just recently, the Queens District Attorney announced charges against several alleged fraud ring participants,
Okay.
including the alleged mastermind runner, Jaime Huirococha, and Victor Murillo. They're charged with staging 3 car crashes, reckless endangerment, conspiracy, insurance fraud, allegedly with promises of cash payouts to participants.
And there was evidence.
Compelling evidence. These charges apparently came after a shocking dashcam video of one of these collisions surfaced, essentially providing pretty clear evidence of the alleged staging.
Wow, dash cam footage. Okay, now that we've seen the scale of this alleged fraudemic, let's zoom in even closer. On the specific tactics and the financial flows at play,
Right.
to really understand the inner workings, let's turn our attention to another federal case. Great American Insurance Company v. Luis Manuel Garcia Salcedo, which, interestingly, involves the same law firm we mentioned earlier, Subin Associates.
That's right. And what's particularly revealing here is that Great American, which is an excess insurer,
Meaning they cover claims above a certain amount.
exactly, they're aggressively pushing to compel Subin to produce subpoena documents, alleging fraudulent acts and even enterprises dating all the way back to 2012, 2013.
Going back quite a way then.
Yeah. The original Salcedo personal injury action settled for what's described as an unsupported $6 million.
Unsupported.
That's the term used. Great American is now seeking a declaration that it has no duty to defend or indemnify, and they've amended their complaint to include common law fraud by Salcedo, by Subin, and by a Dr. Gerling.
Okay, so this gets to the core of the alleged scheme. What's the claim?
The claim is that Subin perfected a practice of finding impoverished immigrants, promising them instant access to money through something called litigation funding.
Okay, litigation funding. We hear about that.
In exchange, they would allegedly participate in staging accidents, receive unnecessary medical treatment, and cooperate in pursuing these huge damages, verdicts, or settlements. Often, the source says, with relatively little to no ultimate payout for Subin's plaintiffs themselves.
So the plaintiffs don't actually see much of the money. How does this litigation funding part work in the alleged fraud?
Right, the financial aspect is absolutely crucial here. Litigation funding is basically a cash advance, provided to plaintiffs by a third party in exchange for a cut of their potential settlement.
So they can afford the lawsuit.
It allows plaintiffs to pursue claims without upfront costs, sure. But in these alleged schemes, it also creates a huge financial incentive for everyone involved. The Great American Motion highlights the role of those runners, again, like Tanvir Chaudhry, who owned Tri-State Medical Liaison Services, Inc.
Tri-State Medical Liaison Services.
According to the source, Subin's own production, their own documents, show Tri-State received a $15,000 payment from litigation funding for Salcedo shortly after the lawsuit was filed.
$15,000.
And crucially, with no invoice or check provided in the documentation. The source describes this as just the first layer of the onion, suggesting much deeper financial connections.
A complex web of financial incentives, it sounds like.
Exactly. Our sources detail multiple litigation funding companies involved: Best Case Funding 2, Pegasus Legal Capital, Chroma Legal Funding LLC, providing large sums of money to Salcedo.
And the medical angle. You mentioned unnecessary treatment.
Equally concerning, allegations of complicit medical providers like Kolb Radiology and Dr. Michael Gerling, an orthopedic surgeon, performing unnecessary medical treatment. The source specifically mentions an alleged unnecessary neck surgery on Salcedo.
An unnecessary neck surgery? That's incredibly serious.
Very serious ethical questions arise there.
And the Salcedo case itself, you mentioned inconsistencies.
Stark examples, yeah. The accident was initially reported September 13, 2013. Salcedo supposedly working to remove a boiler at one address.
Okay.
Then, an amended complaint shifted the date to September 12, 2013, at a different address.
Changing the date and location.
Red flags.
Right.
Furthermore, a witness, Moises Hernandez, allegedly hired to demolish a boiler, later denied Salcedo was injured or even working at the premises at all.
So the witness contradicts the whole story.
These contradictions, according to the source, point directly to the alleged fraudulent nature of the entire claim, undermining its very foundation.
And how has Subin responded to these specific allegations in the Salcedo case?
Well, reportedly, they've resisted producing key documents, like the intake sheet and the retainer agreement.
The initial documents when they took the case?
Exactly, claiming attorney-client privilege. But Great American argues these documents are subject to the crime-fraud exception.
Explain that for our listeners.
Right, so even if something is usually protected by attorney-client privilege, that protection can be overridden if the communications were made to further a crime or a fraud.
So Great American is saying these documents were part of the alleged fraud itself.
Precisely. They argue these documents were the first formal steps in Salcedo and Subin's alleged fraud scheme. And the sources note, this pattern is eerily reminiscent of other older cases involving Subin from 2013 and 2016.
Suggesting a potential long-standing issue.
That's the implication.
Okay, moving beyond the individual cases now, our sources also shed light on broader legal tactics and their impact on the system, particularly when defending against these alleged schemes.
Yes, we've seen a fascinating, and you could argue perhaps problematic, tactic in jury selection. Voir dire.
That's questioning potential jurors.
Correct. Plaintiff counsel have apparently inquired about potential jurors' bias regarding undocumented plaintiffs.
Okay, seems reasonable to ask.
Then successfully moved to strike jurors who expressed reservations. Fair enough. However, having injected legal status into the process during selection, they later tried to prevent any mention of the plaintiff's undocumented status during the actual trial.
Wait, so they use it to vet the jury, but then want it excluded from the trial itself?
Exactly. It raises a serious question about fairness and due process. Should that kind of bait and switch, as some might call it, be allowed?
Tricky legal ground there. So what does this all mean for those actually trying to defend against these types of alleged lawsuit fraud? Are there effective strategies? Our sources highlight some surprisingly simple ones.
Precisely. Lawsuit fraud is a broad term, right? It covers staged accidents, staged medical treatment, unnecessary medical treatment.
All the things we've discussed.
Yes. Two key existing defenses, which might seem basic but are powerful, are general denial and sole proximate cause.
General denial just means we deny the claims.
Essentially, yes.
Right.
And sole proximate cause means arguing something else entirely was the only cause of the injury, not the defendant's actions. These can effectively subsume the fraud defense without needing a specific, complicated fraud claim pleaded up front.
How does that work in practice?
Well, for example, in one case mentioned, Samantha Walls v. Snyder Avenue Realty Associates, Ltd., even without a specific fraud amendment in the official court filings, the trial judge allowed the defense to argue straight to the jury that this accident never happened.
Because it was covered by the general denial.
Exactly. Covered by the general denial in their initial answer to the lawsuit. This is powerful because it allows defendants to argue fraud essentially, and introduce supporting evidence directly at trial, even without formally pleading fraud.
Interesting. So existing tools can be used effectively.
They can be.
Okay, finally, let's connect all this back to a real-world impact on you, the listener, the consumer. There's compelling evidence, apparently, that legislative reforms in other states can make a tangible difference, like with insurance costs.
Yes, what's truly fascinating here is the data coming out of Florida. Reforms were implemented there, specifically to tackle predatory lawsuit abuse.
And are they working?
The results seem pretty dramatic, actually. The top 5 auto insurers in Florida, they're cutting rates by an average of 6.5% this year.
Cutting rates, that's unusual these days.
It's a massive turnaround from a staggering 31.7% increase in 2023.
Wow, a huge swing.
And it's led to Florida having the lowest personal auto liability loss ratio in the entire nation for 2024, which is a direct indicator of reduced claims and costs hitting the insurers.
That's incredible. A direct, tangible benefit for consumers from legislative action.
And it directly contrasts with the national trend, where auto insurance costs continue to fuel inflation. Nationally, they rose 6.1% over the past year.
So the takeaway seems clear.
When states actively tackle lawsuit abuse reform, as the source puts it, costs to consumers can actually drop.
It really underscores the financial ripple effect these alleged fraud schemes can have on everyday people and how policy choices can genuinely make a difference to your wallet.
Absolutely.
We've unpacked a lot today, from specific allegations of staged accidents, fraudulent claims in New York courts, to the legal strategies used to combat them, and even how state-level reforms are impacting your pocketbook.
Yeah, this deep dive really reveals how complex and interconnected our legal systems are, and how, critical thinking and vigilance are so important in understanding the information that shapes our world, especially when it comes to something as fundamental as justice and financial well-being.
So what does this all mean for you listening right now? Maybe consider how allegations of fraud in just one sector of the legal system can impact almost everything. From your insurance premiums, certainly, to the very integrity of the justice system itself. And here's something to think about. How might increased transparency or maybe different approaches to that litigation funding we talked about change the landscape of personal injury claims in your community? That's something to mull over until our next deep dive.